all I can say is do your schoolwork. Do your schoolwork. Do not like to be spoon-fed. Question 4, you go through your study guide. Go through your study guide. It's got almost, that's why we were to reference, right? It's got all the answers you need. I mean, question 4 that speaks of a Latin word that means against men. You just need to elaborate, explain that. That's it. That is it. Like, I don't know how to put this, but I don't have the I do not footnote here. I do not put any reference to the study guide, but this I got from the study guide. You just study, do your schoolwork, then you'll be fine. But the question 4, that word ad hominem, I'm not Latin. It's a Latin word that means against men, and argumentum ad hom. Hey.
Hi everybody, welcome back to my YouTube channel. My name is Sakwadi Wakarabutla and I'm back again with yet another video. How is it going, guys? Are you ready for exams? So I want to do a bit of exam preps, so I'll do question papers and explain a few things here and there. This is not a question paper, but it's the case summaries for the law of persons. I want you guys to know how I wrote this 3 times and passed it the 3rd time only with a distinction. What helped me was I taught myself to know the citation of a case, to know the facts of the case and the decision. That's what I taught myself, and I will show you guys. There are these cases that they're always gonna be here. It is important to know this one ex parte Bedulstein Camp one. It is very important because it speaks of the necessitous fiction, where rights of an unborn child or entitlements in this case can be preserved until they are born, if they can gain from, but then let me read this case. It says the testator left the residue of his estate to his daughter and to the first generation. The testator's daughter was pregnant at the time of the testator's death and subsequently gave birth to Paul Johannes. The executor to the estate sought a declaratory order on the issue of whether only the children born at the time of the testator's death would inherit, or if Paul Johannes, born after the death of the testator, would also be able to inherit. Gida and Daniel Johannes, those were the 2 children that were already born before, or when he died, before the date he died. Held that the words by date of birth, that's what I think this Afrikaans mean, is sufficient enough and without ambiguity to exclude the unborn child from the estate. Paul Johannes was of the opposite opinion, stating that there's no evidence that the testator wished to exclude the unborn child from his will. Right? The Judge de Villiers held that the necessitous fiction should be able to inherit, the necessitous should be able to inherit by means of the necessitous fiction, subject to being born alive, and is it being to the advantage of the necessitous. Okay? He further held that Paul Johannes is entitled to his share of the estate in equal amounts to his mother, brother, and sister. So you can see now, this situation benefits this unborn child. It's point blank, and the necessitous fiction came into play and was able to make sure that Paul Johannes, born after, inherits also. So this is, you see now, it says the benefit and you're subsequently born alive. So this is what happened. Okay guys, sorry about that. So this is a very, very famous case. It will come, I'm sure something like this will come. That has got to do with the Road Accident Fund versus Matiti. This is the case where a pregnant woman had an accident, and which was caused by the other driver. The pregnant woman's child was subsequently born with injuries and mental disability. The Road Accident Fund raised a plea. It contended that firstly, an unborn child is not a legal subject, which is like a person, and is therefore not entitled to compensation. And secondly, because an unborn child is not a legal subject, the driver does not owe duty of care to the unborn child. Right? So remember what I said previously about the unborn child's rights being protected. If the situation will benefit them, then yeah, stuff like that. However, here they could not raise an action of necessitous fiction because upon the decision, the Supreme Court of Appeal decided that it would be intolerable if our law did not grant an action for prenatal injuries, and that such an action should be based on the law of dialect. So in order for the law of dialect to be fully adhered with, it has to be an issue between a legal subject and a legal subject, not an unborn baby. Those are the rules of the law of dialect, right? The court held that according to the ordinary principles of the law of dialect, unlawfulness and damage are separate elements for dialectual liability, and that the child's dialectual right of action becomes complete when he or she is born alive. The assertion that the driver of the vehicle did not owe Z a legal duty because she had not been born must be rejected. As a result, of the judgment, all future claims for prenatal injuries will have to be based on ordinary principles of the law of dialect and not of the necessitous fiction. The necessitous fiction will still apply in other areas of the law. So you do see the difference now, because now dialectual rules between a legal subject and what's this and another one. So at the time this thing happened, I hope it's a bit clear. It's clear enough between the two differences of the cases. Okay, then we have this one, Christian Association of South Africa versus the Minister of Health. The plaintiff sought an order declaring that the Choice of Termination of Pregnancy Act 92 of 1996 is unconstitutional, striking it down in its entirety. The plaintiffs argued that life begins at conception, therefore termination of pregnancy is violation of Section 11 of the Constitution of the Republic of South Africa 1996, which affords everyone a right to life. The defendant argued that if a fetus is not a barrier of rights in terms of Section 11 of the Constitution. The legal question was, does the wording of everyone or every person in the Constitution include an unborn child as a legal subject from the moment of conception? Judge McKeith held that the question is not one to be answered by medicine, but by proper interpretation of Section 11 of the Constitution. Let's continue. He further stated that if the drafters of the Constitution intended to protect the fetus, specific reference to the protection of the fetus would have been made in the Bill of Rights, Section 28. The Transvaal Provincial Division of the High Court held that to afford legal personality to the fetus would impinge to a lesser or greater extent on the human rights to dignity, life, privacy, religion, belief, and opinion, and healthcare. The court has concluded that the particulars of the claim fail to make out a cause of action and the exception must succeed. So you're gonna get a question that's asking you about this case. So the most important things that you must learn about these cases is the facts and the decision, honestly, because they ask you around that. Okay, Here's another one that you will read up. If anybody needs these summarized cases, I have my number on TikTok. Okay, I'll just send you on WhatsApp if you WhatsApp me. Then we have Bagel Hole. This case, a tester left an amount of money to beneficiary. The executor of the estate had paid the money to the master of the High Court because the tester could not be traced. The executor applied for the order to pay to pay the estate over to him so he could pay the money to the tester's remaining heirs, as if it was alleged that the executor had not been heard from in over 15 years and therefore is presumed dead. The court refused to issue the presumption of death. What should the legal question being, what law system should be applied during the hearing of such a case in question? Judge Ignace refused to grant the order of the presumption of death when applying Roman Dutch law principles, which are in his opinion the correct system of the law to be used. So, just as I said, this is what you need to know: the facts, the decision, and then you'll be able to know where is it applicable when you are asked a question on your multiple choice. I know right now maybe I'm not making much sense, but I will be doing questions for PVL. I'll do a video for it, and then you will understand where exactly I was going with this. Okay, I'm just looking for the famous cases. Okay, guys, all these quick cases are important, but I'm just pointing out the ones that I know for sure you're gonna get. We have M versus R. Okay, the applicant and the respondent had, as you can see there, on a regular basis, the respondent alleged she was a virgin at the time she and the applicant had on a regular basis. The applicant deemed this and she had another boyfriend. Oh, the applicant denied this and she had another boyfriend. The respondent denied this. In January 1979, the respondent informed the applicant that she was pregnant. The applicant subsequently paid maintenance for 8 years. The respondent informed the applicant that she had applied for an order of an increased amount of the maintenance from the applicant. The applicant applied for paternal testing and the respondent opposed this application. The respondent, in the meantime, married R, and the child as accepted and loved R as his or her father. The respondent and R planned on telling S during the year that the applicant is her father. The court felt it was crucial for the child's development and happiness that clarity in this matter must be reached. Okay, the judgment was Judge Kotze held that the court has to intervene in this particular case because it would be the advantage of the child in question. He further held that the court could compel the respondent to go for blood tests once again because it would be at the advantage of the child to know his or her father. Okay? This case, look into it. You need to know it. S versus L. It's gonna come. S versus L is also gonna come. Please study it, read it. I think I've put it here long enough for you to pause and read it. Okay, this one also is gonna come. Probably gonna come. So if anybody needs this material, my WhatsApp number is on TikTok. Just WhatsApp me. I'll send you this summarized cases. Okay. This one, Fraser versus Children's Court, coming. This one I'm not sure, but read this. Please study it. Peterson versus Maintenance Officer. This one. Okay, even this one, study it. This one, please look into it. Good faces, Davids, but this one, look at it. Dixon, I used to call it Dick something. Dickens. Yes. Yeah. Okay, study this. Yeah. So this is almost all of them, unless they've added more cases. The cases that I tried to read and try to point out to you, please look into them. They're gonna come. Anyway, that will be all for this video. I have to leave now. I have to leave and record the questions and upload them for your practicing and explain a few things about the answers, because you just don't want to know the answer and not know what's going on. Anyway, thank you for tuning in. I love you. Mwah.